Circuit Court for the County of Kent is now in session. Honorable J. Joseph Rossi presiding. We are here in the case of the People's State of Michigan versus Charles Johnson Jr., case number 24-05649FH. This hearing is being recorded on Zoom and live streamed on YouTube.
And Mr. Johnson, you're before the court today because you failed to appear for a trial date in front of Judge Mims on July of the 14th of this year. I am presiding for Judge Mims today in her stead. Why didn't you show up for that trial date a couple weeks ago?
Because I didn't receive no letter in the mail or nothing, and I tried to contact my court attorney, and he did not get back in contact with me at all. I didn't really want to miss no court date, other than that, I'd have been there. It's just, like I said, there's been a lot going on. I've been having problems with this guy ever since I had him. Like one time they put a letter on my door, on the door I had a PPR on, and I missed court that time. And it was like crazy how they keep just doing stuff that I'm giving them a correct address. I gave them a whole new phone number and everything because my phone was broke.
All right. And is your assigned attorney Michael Anderson?
Yes.
All right. Well, what I am going to do is I'm going to remand you at this time without bond. I'll let Judge Mims set the bond. Let me make sure we've got a correct address for you, and I'll let Mr. Anderson know that you're in custody so he can reach out to you. What is your correct address?
My correct address, Southwest, Wyoming, Michigan. But I'm saying I was told that I was supposed to get another rebond and get released because my court services who I talked to when he got me arrested that day, well, when I went in and he arrested me that day, they said I was supposed to get rebond and be out the next day. This is what I was being told. And then plus I haven't been taking my medication like I was supposed to. I got high blood pressure and all that. I got it in doctor's notes that I'm supposed to be taking, and they've been giving me wrong food in here. They're not giving me my medication and all that. I could be in high risk to having a heart attack anytime if I don't get my meds.
Certainly don't want that to happen. Like you say, I'll have Mr. Anderson reach out to you and make a bond hearing as soon as possible. I just don't want to set the bond instead of Judge Mims. I want to allow her to do it since it's her case and you missed that trial date. So wish you the best of luck, Mr. Johnson.
What's that mean? So basically what, I'm gonna wait or something?
You're gonna wait. Yeah, he'll reach out to you. We'll send notice over there quickly today that you are in custody.
Yeah, because it's been 2 days. I ain't take my meds, man. It's 2 days.
I understand. And have you told the jail nurse your prescription and stuff so they can?
I told them that like 3 times.
Yeah,
the past couple of days.
No, and blood pressure stuff, at least, it's not a controlled substance. They ought to be able to get it in the jail, but I know that's not a snap your fingers and it happens. Sometimes it takes additional time. I'll put a note on that because of your medical condition, you want contact as soon as possible.
Yeah, because I'm diabetic too. I got that on my paperwork too.
No, we do want to keep you around, Mr. Johnson. It's not anyone's desire that that you have a heart attack in custody. So I'll make a note on the file.
All right.
Good luck to you, sir.
Yeah, thank you.
All right, next is Nowicki.
Jeffrey Nowicki.
Thank you. Okay, we are here in the case of the People's State of Michigan versus Jeffrey Nowicki, case number 24-12247FH. This hearing is being recorded on Zoom and live streamed on YouTube.
And Mr. Nowicki, I'm Judge Rossi. I'm the presiding judge today who is handling these matters for Judge Mims. And you're in front of me because you failed to appear for a sentencing hearing in front of Judge Mims on July 16th of this year. Why didn't you show up on that date?
I was in the emergency room
Okay, and what was going on in the ER?
I had a laceration on my eyeball.
Oh,
I sent the doctor's papers and the pictures and all that to my lawyer that day.
and who's the lawyer representing you?
Lindsay Dubas.
Okay. All right. Well, what I'm going to do at the request of Judge Elmore's chambers is I'm going to remand you to the jail without bond at this time. I'll have Miss Dubas reach out to you, and then she can set a bond hearing in front of Judge Mims, so Judge Mims can set bond in your case because you did fail to appear for sentencing. And of course, you will get credit for any time that jail time that you put in. Judge Mims will give you credit at the time of sentencing. So at this time, you're going to be remanded without bond, and we'll send notice to Miss Dubas that you're in custody.
Okay.
Good luck to you, sir.
Yep.
We have Michael Rousey.
Okay, we are here in the case of the people of the state of Michigan versus Michael Rousey, case number 24-10886FH. This hearing is being recorded on Zoom and live streamed on YouTube.
And Mr. Rousey, you are in front of me today because I'm the presiding judge for Judge West,
Yes.
who handles your case day to day. And he issued or revoked your bond because you failed to appear for a status conference in
Yes.
front of him on July the 7th of this year. Why didn't you show up in court when you were supposed to?
I missed the date is what it is. When I realized it was, I just said, well, they're gonna take my bond anyway. I thought it was the 10th and it was the 7th.
Okay. All right. Well, it is important that you obviously make it. What I'm going to do is I will remand you to the jail without bond at this time. Do
Yes.
you recall who your attorney was?
Pardon me?
Do you recall which attorney handled your case?
Nationalize.
Okay, we'll send a notice over to Miss Lays that you're in custody, and she should reach out to you, and then you can request bond again in front of
Yeah.
Judge West. Because it's his case, I'd rather have him set the bond in this manner.
You didn't reschedule the status conference? Can't just reschedule?
He did not give us a new status conference date, but I'm sure that he will do that, and Miss Lay should be able to tell you when that is.
All right. You know,
Good luck to you, Mr. Rousey.
thank you,
That's it.
sir.
All right, Your Honor, is there anybody else? Oh, wait, we have Schultz. That's right, I forgot about him. Okay. Your Honor, we have Katie Schultz.
We are here in the case of the people of the state of Michigan versus Katie Schultz, case number 25-04561FH. This hearing is being recorded on Zoom and live streamed on YouTube.
And Ms. Schultz, you're in court today, and you're in custody because Judge Denenfeld issued a bench warrant based upon your failure to report when required to court services. My name is Judge Rossi. I am the presiding judge today for Judge Denenfeld. Why weren't you reporting to court services as ordered by the judge?
I was unaware that I had court services. I do believe that I had a PSI maybe that I had missed. But I'm new to this. I've never really been in trouble before, so I'm kind of just learning as I go here, and obviously learning the hard way that I missed a PSI from what I'm understanding from my paperwork that I had gotten from my mom when I reached my mom.
Okay, all right.
I am currently
and
homeless at this moment, so
I see. So the mail goes to your mom, and you're kind of dependent on
Yes.
checking in with her
yes.
as to what you're getting. Well, I can tell you there are two separate things that you need to do. Court services is on the second floor of the courthouse, and it is an office that you check in with. They sometimes drug drop you, and they're kind of in charge of keeping track of you while your court dates are pending. The PSI is a separate event that it is done by the probation department at 82 Ionia. It's a whole separate office, and you'll have another opportunity, or at least you should, to give them some input for your PSI. The fact that you're doing a PSI, okay, that means you were awaiting a sentence date, which is coming up here on August the 27th at
Yes.
1:30 p.m. Okay, well, what I'm going to do is do you recall who the attorney that was representing you is?
Tamara Pierce.
Okay, we'll inform them that
All right.
you're in jail, and I'm going to remand you to jail at this time. Judge Denenfeld has
Why-
sent.
What, you're gonna keep me in here?
Well, Ms.
That's
Pierce should make a bond motion in front of Judge Denenfeld for you,
I'm really
because
trying to get to rehab. I have, I was supposed to make it to Network 180 to go to sign up for waiting for an open bed, and being in here is not helping me and reach towards my goal of being with my children.
yeah, no, I
Get in
get
that place.
that. The good news is, first of all, you'll get credit for any days you do in there when Judge Denenfeld sentences you. He does have a sentencing date of August
Yeah, so I
27th.
sit in here till the 27th? That puts
No,
me
your
behind.
attorney can we'll notify your attorney that you're in custody. They can then approach Judge Denenfeld and request a
Can you
bond
please
condition
reconsider?
before then.
I will go straight to Network 180 and I will straight to rehab. Please, it's gonna really mess up my whole child case. I'm supposed to be getting my kids back in 90 days, and I need to finish this program to get my kids back. You're
Yep.
this would really puts a big kink in it. Please, can you reconsider?
Is there a Child Protective Services
No CPS case, it's just they are in state custody because I am homeless. I'm
Okay.
trying to get into Network 180 to get into rehab, to get to rehab classes finished that I'm required to finish, and I get my children back. They will give me housing, they will give me everything I need to get back on track. This is really putting a hindrance in me getting my children back. I need my children back to be well. My dog is out there on her own. I need to get out of here to get my children back. Please let me reconsider. Please reconsider a PR bond, please. I promise you will not be disappointed.
Yeah,
have-
I hesitate to do that because
I swear to you, my kids are right there in front of my face. 90 days. I've waited a year for this. Please do not put another month in it. Please.
well, I won't necessarily be another month. Your attorney will notify
I
your
know, but
attorney
any
that you're
extra
in
time is
custody.
really just is killing me. I'm in here and
Yes,
I'm
well, I
not doing
understand,
okay.
and your attorney can make that bond motion, but because it's not my case, I don't feel like I should be the one to
Please,
set
please,
the
Your
PR
Honor.
bond and
Please.
release you.
Please.
Because of course the
Please.
concern is you wouldn't show up for that.
Please. I will show
following
up. I
sentence
swear. I'm
date.
writing it down right now. 27th at 1:30. I've got
Yep.
this.
No,
I will be in
I get
rehab.
it.
I will be inpatient rehab. Inpatient rehab. How am I gonna miss a court date?
Well, you can do it. I have had many
I have a
women
90-day
and
program.
men appear from rehab by Zoom, just like you're doing. You can arrange that through your attorney. The one thing I would advise you, Ms. Schultz, is Network 180 does have a liaison there at the jail.
Please reconsider.
I'm not going to reconsider the remand at this point, but you can reach out to the Network 180 liaison there at the jail, and they can do the substance use evaluation and get you
I've
at
already
least.
had that all done.
Okay, continuing on, well, they can help you continue on that process, and so as soon as your attorney
So I'm gonna
post
stay here for
bond,
another
then
30
you can,
days.
right,
Thank
but
you.
you're gonna have to wait until that point. Good luck to you, Ms. Schultz.
Yeah,
Thank you, Your Honor.
great. Bullshit.
We are here in the case of Preferred Credit Union versus Franthea Price, case number 25-05340AE. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court for a motion today, although it was not clear to me what the nature of the motion is. So as an initial matter, Ms. Price, would you state and spell your full name for the record, please?
I just want you to know, Your Honor, I'm here specially, not generally, and do so sui juris as the authorized agent for the family, Franthia family of the Price estate. So my appearance is strictly limited to the matter noted today and it does not grant any joinder to general jurisdiction, nor does it have any waiver of rights or imply legal disability or association with any bar guild.
Well, I get it, Ms. Price. However, I can tell you that I'm a general jurisdiction court. I operate under the United States Constitution and the Michigan Constitution, and those are the only things that give me jurisdiction to act or make any decisions. So, if you want me to decide anything in your case, you're going to have to be within the jurisdiction of my court. So, and we don't have to hammer that completely out at this time, but I do need you to state and spell your name.
Franthea, Franthia.
All right. Last name Price, Price.
I am.
Very good. And Mr. Bakikuo, would you place your appearance on the record, please?
Thank you, Your Honor. May it please the court, Stephen Buquicchio, Buquicchio, P number 62076, on behalf of the plaintiff preferred credit union.
Very good. And Mr. Bakikuo, this is not your motion. This is Ms. Price's motion.
It is, Your Honor, although like you, I'm a bit confused as to what the relief she's seeking here. I'm prepared to assert preferred's position legally here, and we'll wait for the court's direction as to when I can speak on that.
Very good. Well, let me go back to Ms. Price, because it's her that initiated this motion appearance. What are you asking me to do at this time, Ms. Price, in a legal sense?
I respectfully request that the court take judicial notice pursuant to MRE 201B of the following two documents I previously filed into the court record. One is Exhibit J, OC 10, subpoena duces tecum, demand for custodial records. And number two, supplemental notice of clarification regarding the constructive subpoena duces tecum. These materials, Your Honor, are supported by the Federal Reserve Operating Circular number 10, Appendix 3, UCC Article 8, subsections 8, 102A, 14, and 15, 12 CFR, subsections 225 and 31 CFR, subsection 203, which
Let me
collectively.
just pause you just a minute, Ms. Price. The one thing I recognized of everything you said there was the Michigan Rules of Evidence and the term subpoena duces tecum, meaning you're directing a discovery subpoena. Is that directed at Preferred Credit Union?
It is, sir. I also wanted it to be on record because I previously asked for debt validation and didn't get anything in the lower courts. So
Okay.
Your Honor, may I respond?
Yeah, go ahead, Mr. Bakikuo.
A couple things, Your Honor. There's a lot to unpack there. Number one, we have a judgment in this case. So any attempt for discovery is outside, respectfully, the jurisdiction of this court at this point. I suspect what Ms. Price or the estate of Ms. Price or the Franthia Price family of Price estate is seeking to do here, Your Honor, is undo the judgment that was legally entered in the lower court case. So I would just say, Your Honor, what she's asking for is irrelevant and outside the bounds of what this court can do. The case is over as far as the district court is concerned. I can get into the argument as to the debt validation. I did produce with our response a motion for summary disposition there that did provide for the debt validation notice. Ms. Price continues to mislead the lower court and now this court that a debt validation was not given. It was in fact given. This is a simple credit card case, and she is trying to use far-flung, I can't even characterize what these arguments are, Your Honor. I want to be respectful of Ms. Price's ability to defend this in pro per. But
I object, sir. I'm not in pro per. I'm sui juris. Thank you.
Okay, whatever that means, Your Honor, this is making a $12,000 credit card case so much more for my client. And Ms. Price pursuant to the agreement, is responsible for those attorney fees. And I know there's a fine line between allowing a defendant in pro per or sui juris or whatever the name she's calling it, but this is just abuse of the process, Your Honor. She is alleging things that have no legal bearing whatsoever. She's asserting UCC, bill of cost, bill of ladings, bill of exchange, foreign bill of exchange. Your Honor, I don't even know what this means, to be quite honest, and I've been doing this for over 25 years.
Let me just pause you for a minute, Mr. Bakuiko. Something I did see that I did recognize as I paged through the file was the affidavit of a transcript of the lower court record, which is normally produced in a case that comes before me on appeal of the district court decision. Are you aware of a notice of appeal filed?
I am not aware of that, Your Honor. I suspect what was done here, Your Honor, was in the lower court. The judge indicated to Ms. Price that she's ruling in favor of preferred, and she was welcome to appeal that. And I suspect this is her attempt to appeal that. And to the extent Your Honor is ready to rule on her appeal and either, overturn the lower court's decision on the judgment or some other ruling here, I'm going to proceed as though she is seeking to undo the judgment that was entered against her. That's all I can surmise by this, Your Honor.
Yeah,
Okay.
if I may speak,
Yep, go ahead, Ms.
I
Price.
believe the opposing counsel has stated he has not received an appeal. I have sent that, all the information you received. He's received that. I have the record, that the hard copy receipt from the post office. I sent this certified mail. So I do have the receipts of all of those things. Whatever you have, his office received it as well. I do have the proof of service and all that. The fact of the matter that he continues to mischaracterize this as solely a simple credit card debt that I'm trying to avoid, that is simply a mischaracterization of what I'm attempting to do, as is unsupported on the record, that I've attempted through bill of exchange, and I've asked and requested and have not received a simple application. A copy of it is not supported of the verification that this is a bona fide contract, and lawful consideration, if it's not done, is violation of a contract as well.
All right. Well, here's my where I sit on this one, Ms. Price, is that my position legally here is I can sit as the Court of Appeals to review the judgment in the district court. And what I appear to have in front of me here is a partial appeal, in that I do have the record, at least at what looks like to me, it's not a full record. It's just a transcript of the summary judgment hearing at the in the district court in Kentwood. Normally, when I get the record from them, it has a whole bunch of other documents that explain, in a nutshell, how that case was reduced to judgment. And I don't have that, so I don't appear to have an entire record. And what I don't have from you specifically is a document called a notice of appeal that tells me that you're appealing a final judgment and that you want me to review that for its legality. I can tell you, because it is on appeal, it follows the appellate rules of the Michigan court rules, and they are, for lack of a better term, more intricate and harder to follow than the general court rules or the court rules for proceeding in the district court or in the circuit court. There are a lot more hoops to jump through on appeal, and that's really where you are when you're in front of me. And I can also tell you that on appeal, what I'm supposed to do is look at the record that was generated in front of Judge Sturkenberg, and the new stuff that you file with me, arguments or requests for discovery, Mr. Bequicchio is accurate in saying that normally you don't get any additional discovery on appeal. Normally what you do is you make an argument on what happened below, and that might include that Judge Sturkenberg denied you proper discovery and that thus she made a legal error that warrants me overturning that case or sending it back to Judge Sturkenberg for more work or things of that nature. And I can tell you from what I see in the file right now, I don't have the information I would need to decide that. So what I am going to do is direct you to file the requisite notice of appeal and appeal documents within the next 15 days, or I will dismiss the appeal and you'll have to start that process over again, and the dismissal may have a substantive effect on your ability to file another appeal. So what I'm telling you is this appeal that's in front of me right now is incomplete. It's not documented per the appellate rules, which are found in the Michigan court rules. And, I wouldn't have any choice but to dismiss it unless you supplement it with at least bare minimum a notice of appeal and sufficient information to inform me and Mr. Bequicchio what the nature of your appeal is. What it appears that you're appealing from a final judgment. However, all I saw in the final judgment, I think, was the fact that Judge Sturkenberg did grant that on the record. I didn't see. Do you have a judgment and order that you filed, Mr. Bequicchio, a written order in connection with that?
We do, Your Honor. A judgment was indeed entered subsequent to our motion for summary disposition and hearing on that motion. And I believe that was submitted with our response to Ms. Price's filing, whatever that was, Your Honor.
Okay, and unfortunately, I have Ms. Price's filing. I don't think that I have your response. It didn't make its way to me in time to come home with me for the file. So I'll review that as well. But Ms. Price, like I say, there is documentation and it is strictly required by the appellate rules. There's no way, sometimes in the lower courts, a judge can say, well, you're appearing as a sui generis pro se, a person appearing without an attorney appearing beside them, and I can give you a break on following some of the rules. That's not true at all on appeal. Appeal there, either you follow the rules or your appeal gets dismissed. It's kind of a black and white system in that regard, and that it doesn't give me very much discretion when I'm sitting in that appellate jurisdiction. So you do need to get that in order, and I'm going to have it ordered that it be done within 15 days. That's, I think, all we can do for today.
Your Honor, as a procedural clarification, Your Honor, to the extent Ms. Price does supplement her appellate filing and the court finds that it is inconsistent with the appellate rules, will another hearing be required, Your Honor? Or
no, I'll just sign an order of dismissal if I don't have the proper documents to initiate the appeal.
Terrific. Thank you, Your Honor.
Very good.
Your Honor, you said I have 15 days to get the information because I believed I sent all of this stuff in appropriately. I went into and handed it in and got the proper documentation. And the fact that you said you don't have that information is a little
I do have a bunch of
it.
stuff that you filed that appears to have been printed out by you. The one thing I have, and the only suggestion I can make, Ms. Price, there is a legal assistance center on the 4th floor of the courthouse. If you talk to them and say, gee, Judge Rossi said I was missing some stuff on appeal, they can at least direct you to the proper forms to file to initiate an appeal. Because the one thing I did receive here was the notice of filing of transcript and affidavit of mailing, and that's on a Michigan court form that I recognize. And what I then got was a transcript of that hearing, the last hearing, it appears, in front of Judge Sturkenberg. However, there is more stuff. They need to, what really they need to do is transmit the entire record of that case, or you as the party need to assemble that record on appeal, the record of what happened in the lower court, and get it to me on appeal. And that basically looks like those transcripts plus any paper documents in the court file that happened in the district court. And I don't see any of those in my appellate
But
file here.
they told me that I put there that they was gonna mail it to you. They mailed me a copy and they said they was gonna mail you a copy because I purchased the transcripts and everything.
Yep, and I did get the transcript, the one, but that's just the transcript of the the hearing on appeal, and that is part of what I need. Well, and I said I didn't have a claim of appeal. I stand corrected as I'm paging through here. And I have to tell you, Ms. Price, the filing of the the additional documents here, I know you believe it's important in helping me to decide your case, but I can tell you what it's doing in a practical sense is making it really hard for me to file, just to track the documents that actually do trigger my duty to decide stuff on appeal. So I do have a claim of appeal. Looks like it was signed by you on June the 13th of 2025. So really what I need on appeal then, and again, I'm also prohibited, as the folks at the Legal Aid Center are, from giving legal advice. But I can tell you, if I'm to decide any appeal, I'll need a copy of the entire lower court record on appeal. And the record on appeal, like I said, usually it's assembled by the parties to the appeal. Usually you, as the person, the individual appealing the decision of Judge Sturkenberg, are the one that's going to put that together. Mr. Bequicchio can contribute to that record if he wishes to do so. And then that gets submitted to me, kind of as a, here's what happened at the lower court. It tells the story of that in those filings and pleadings filed at the lower court. And then you file a brief on appeal, and your brief makes the arguments as to why Judge Sturkenberg made legal errors in her decision making. And since I'm requesting that brief now, I just thought I was needing the claim of appeal, but since I have a claim of appeal that properly initiates the case on appeal, what I really need then is that record on the lower court, and then I need a brief from you explaining the errors that you think Judge Sturkenberg made. And I'll tell you, I will not be receptive to documents telling me that Judge Sturkenberg or I didn't have jurisdiction. That would be in effect saying, Judge, I'm arguing that neither of the courts could really decide this case because of my legal status, sui generis, or whatever magic words you're trying to invoke there. That just doesn't work. And the reason it doesn't work, particularly on appeal, is I have to have jurisdiction to decide the appeal in the first place. And if you're telling me I don't have jurisdiction, you're as good as telling me, as judge, dismiss my appeal because you can't decide it anyway. And so in other words, you got to give me more than that. It's got to be an argument based on Michigan law as to what mistakes were made by Judge Sturkenberg in the court below, and then I can decide the matter on appeal. And since I'm looking for the brief on appeal, that's a little harder to put together along with that whole record. I'll extend the time for the filing of the record on appeal and your brief on appeal. I'll give you 60 days from today's date. We're at July the
25th.
25th. Yeah, sorry, my glasses. I'm using a backup pair of glasses because my regular ones are in the shop. So 2 months from today will bring us to September 25th to have those documents filed. And then I'll be able to decide those. And I'll also tell you, Ms. Price, the way it works on appeal is I don't need to grant. You can request oral argument, which would be another version. Today, really, this is more of a status conference. It's not so much oral argument because I couldn't make head or tail of what the file was asking me to do. You can request oral argument if you want it. I don't have to grant it on appeal. Sometimes I just review the record and the filings and, decide the appeal based on that. And of course, Mr. Bequicchio, after that 60 days, can file whatever he wants in response to your arguments on appeal. And, likely that'll be a motion to dismiss the appeal saying, Judge Sturkenberg did everything right and there's nothing to look at here, folks. So that's kind of how it works on appeal, just for your information. And like I say, if you need help with at least the forms part of it, the Legal Assistance Center on the 4th floor of the courthouse is a good resource for that.
Okay, so am I, just for clarification, because I'm gonna do this right this time, this coming next time. There's 60 days you need a brief on appeal explaining the errors of the lower court.
Correct?
And
And the
then-
record.
And you need a complete record of the two hearings that had taken place.
I need the complete record from the lower court, and that would start with everything from Mr. Bequicchio's complaint that he served you with and the proof of service and all that stuff. Typically, there's a copy of it. Would be as if you grabbed the file from Kentwood and made a copy of every piece of paper in it,
Okay,
plus the transcripts.
okay. Plus, you still need the transcripts as
No,
well?
you already filed the transcript. If that was the only hearing in the case, were there other hearings?
There were none, Your Honor.
Okay, so that was the only time that you two argued in front of the judge. So I don't need any additional transcripts. I just need the record on appeal.
Your Honor, there may have been a pretrial. I can't remember whether or not that was on the record or not, Your Honor. But if it is indeed on the record, the lower court record would include that, of course.
Very good. All right, so that's what I need, is that record from the lower court. Mr. McCuker, I think the appellate rules allow you to weigh in and supplement the record or collaborate on submitting the record to me. I'll leave that to you as to how much you're going to participate and assist with that production. But you two can talk to each other. The goal being to get everything in front of me that I need to decide the arguments that you make in that brief on appeal, which is where you get a chance to make your substantive argument as to any errors made by Judge Sturkenberg.
Thank you, Your Honor. I will say, to clarify from our position, we did respond to the filing of Ms. Price. With that, we included the complaint, the answer, and our motion for summary disposition, and Ms. Price's response to that motion for summary disposition. So that should make its way to the court file. I don't know whether that would be deemed an official record as far as the appeal is concerned with certified documents, but we did put the underlying materials in our response. So that will be contained in your file. And
Copy obviously went to Ms. Price, so she should have received
yes,
all those filings as well. And yeah, normally, right, there is the certified record on appeal gets a simple one-page document from the district court saying this is everything we have in our file. So I would accept either way. If you want to supplement what Mr. Bequicchio sent Ms. Price, or whether you want to just go to the district court and say, hey, I need a whole copy of that file because Judge Rossi's asking me for it, and it's got to be certified because it's on appeal. They at least have done that before down there at the Kentwood Clerk's office, so it'll at least give you a starting point as to what to do. And like I say, I think I'd make my first stop the Legal Assistance Center so you can walk in there with the right form when you go to Kentwood District Court.
Thank you. And then do I use the same case number as well?
No, it'll be assigned, and it already has been assigned a new case number on appeal, which is the one we're here on today. It's 25.
Yes, that number, that's the one I'm speaking of.
Yep, that is the appellate case number.
Okay,
Now, when you're talking to Kentwood and if you're looking for
It's
the
a different
district court
number.
record, then you got to
Yes.
go with that number down there.
okay, thank you. I appreciate your help, sir.
Very good. Good luck to you, ma'am.
Thank you.
Thank you,
you.
Your Honor. Thank you, Ms. Price.
Good morning, Your Honor.
There we go.
All right,
Good morning.
perfect.
All right, we've all made it happen. All right, and can you introduce your client, Ms. Arnold?
Yes, Your Honor, this is Marvin Martin, case number, say it again. Marvian Martin, case number 14L1023 and 14L0590.
All right. Good morning, Mr. Marvian.
Yes.
Thank you for being patient with our technical challenges. And it looks like this is 14L000590 on for review. And would either party like to lay a foundation, or what does the court need to know?
And Your Honor, it appeared that Mr. Martin owed the court 60 days of work crew. He failed to appear for that 60 days of work crew back on September 12th of 2014. However, let me just pull up the docket so that I have the precise dates here. I do believe that he has served those 60 days, and the only thing that I noted that Mr. Martin is currently owing the court is a domestic violence evaluation and an alcohol evaluation.
All right, and I do see docket entries. Thank you, Mr. Tuninga. I do see docket entries regarding serving a significant amount of time at the Coyote Ridge Corrections. And so that was probably the reason you failed to appear for the work crew, is because you were otherwise engaged. Is that the situation, Ms. Arnold?
Yes, Your Honor. He spent 60 months in prison, and during that time, he did do alcohol treatment and drug treatment. Also, he did a Thinking for Change program that dealt with domestic violence treatment. And so for that reason, we're asking that the court close the file today.
All right, and I do notice that these are 2014 cases. And was there any ability to file any proof or any documentation as to the treatments? I have no doubt that he availed himself of important things in custody, but I was just wondering if there was any proof or the city's position in regards to satisfying, allowing those in custody treatment opportunities to satisfy the city's request.
Your Honor, the city has no objection to the in custody satisfying those requirements. Based on the age of the case, the city has no objection to closing the cases at this time with all requirements being found as completed.
All right, so give me just a moment to fashion the order, and then I'll have the parties review and make sure it conforms to the intent. And so, as I understand it, we are closing the file today, finding you in effect in compliance. And give me just a moment here. And requiring no further hearings. Is that the representation and belief of the parties?
Yes, Your Honor. And there was a defendant files proof of completion of alternatives to violence project workshop letter that was sent in back from 2015 in the docket notes too.
Okay, thank you. I'm just going to make some notes about that he completed several in custody programs, just that way that's noted on the court record. And in the other box, I'm going to note it as satisfied the work crew commitment during custody served. And then anything else that wants to be noted on the court order for the record, other than case closed.
No, Your Honor, I believe that's sufficient.
And are there any legal financial obligations outstanding?
Your Honor, I do see that there are two $750, or there's one $750 fine on each case. At this point in time, the city would ask that those simply be sent to collections.
All right. I suspect that is the current status, and I'm not inclined to, with that age of the case, bring those back and revisit those. So if the parties want to review the order on revocation for sufficiency, let me know if there are any additions, deletions, or amendments. And sir, do you have any questions about what happened here today at your hearing?
I just want to know if it's over. So I don't live in Pierce County.
Fair
Yeah.
enough. Well, we're intending to have all your Lakewood cases done today. So that's the intention, is to close out these files so you don't need to readdress those. Does that answer your question?
Thank you.
Okay.
And Your
Anything-
Honor, I don't know if he's being held on any other cases, but I do know that the jails can sometimes have issues if defendant released is not checked.
Okay.
Thank you, Your Honor.
Yes,
Alright.
and he is not held on anything else. It is just.
Okay, well, we will make sure that he is released on this matter without a doubt. All right, anything further from either party?
No, Your Honor.
I'm gonna check.
No, Your
sir.
Honor, thank you.
Sir, I'm ordering that you be given a copy of this order, which shows that your files are closed and that you are released on our matters. And I wish you good luck, sir.
Thank you.
All right, take
I
care.
write an X for your signature and you'll be all good.
I can write my, use my finger.
It's on this touchscreen. Yeah, so you have to push down on it and then, yeah, like that. It's complicated.
That's good.
Perfect. Oh, it might actually erase because it's not full screen. Okay, one more time.
Looks like we're gonna fight technology all day today.
Okay, perfect. All right, you're all good.
All right, next matter.
And the next matter, I believe they're gonna pull he's good. You can send in Mr. Brown. Did they end up taking Mr. Arroyo back? He's still here. Okay, bring him first in, please. Arroyo? Why is? Your Honor, this is Antonio Arroyo, case number 25L0627 and 22L0797. And defense has uploaded a motion to continue. We're awaiting a Superior Court plea that just didn't go like we had thought it would. So we're just pushing it out until the 13th of August.
All right, good morning, Mr. Arroyo. Am I pronouncing your name correctly?
Mr. Arroyo, yeah.
Okay, perfect. And so it's defense motion to continue to August 13th, and I'll hear the city's position.
Your Honor, city has no objection at this time. However, should there be a need for another continuance, the city is going to request a waiver of speedy trial.
All right, so we're not addressing a waiver today, but because of the clock ticking, defense is on notice. If they need more time, they're going to have to agree to waive or extend speedy trial, but otherwise the city is not objecting, as I understand that. So I will grant that motion to continue. I will order that you abide by any previously imposed conditions of release. And it looks like August 13 is an out of custody or in custody date. So I will I'm just going to set an out of custody date just in case you are released. And give me just a moment to locate that. And no change in conditions of release today. Let's see, I'm going to put that for September 9th at 1 p.m. if he is released. All right, sir. And would you like me to attach Horwath Law at the bottom of his order just so he has your contact information, counsel?
Sure, thank you.
Oh, okay. On your order that I'm ordering you be given a copy of today, it has your next court date, both in custody and out of custody, as well as your attorney's contact information. And I'm just reminding you to continue to abide by any previously imposed conditions of release. Any questions for the court?
No questions.
All right. Anything further from either party?
No, Your Honor. Can
No,
I
Your
have
Honor.
your signature?
And it.
Yeah.
All right. Once I get signatures, I will
Thank you.
Okay.
sign off on that paperwork. All right, I've signed that. Wish you good luck, sir, and we'll see you in August.
Right, okay.
Take care.
Good.
Your Honor, this is Jimmy Perales, case number 25L4425.
No.
All right. Good morning, sir.
Good morning, ma'am.
Is your true and correct name Jimmy Perales Jr.?
Yes, ma'am.
Am I pronouncing your last name correctly?
Paralysis, yeah.
Okay, just making sure. Your date of birth, July 22nd of 1992,
Yeah,
and you still reside or receive mail at the 825 address in Tacoma?
yeah.
All right, and this is 25L004425 on for arraignment. Did you have an opportunity to review the constitutional rights that attach at arraignment with an attorney?
Not necessarily, but
You have the right to an attorney, remember?
oh yeah. Okay.
Okay, you did review those rights. Did you have any questions for the court about your constitutional rights?
No, ma'am.
Okay, and I'll turn it over to counsel for entry of plea.
Yes, Your Honor, this is Sophia Arnold. Defense will waive a formal reading of the criminal complaint, ask the court to enter a plea of not guilty on his behalf, and stipulate to probable cause for today's purposes only. And we're asking for appointment without a promissory note, based on unemployment and looking for a job.
All right. I will do a direct appointment to the public defender. Now, sir, you have an attorney appointed on your case at no expense to you. I will allow a waiver of the formal reading of the complaint of one count of protection order violation. I will allow the stipulation to probable cause for purposes of setting conditions of release. At this point, I will turn to the prosecutor. He's going to make his recommendation on your conditions of release, and then I'll allow you and your attorney to respond. Okay.
The city has no objection to the defendant's release on personal recognizance under the condition the defendant have no hostile contact with the victim. Our office has successfully contacted the victim in this case. She has specifically requested that a no contact order not be imposed. It's the city's usual procedure to ask for a no contact order in this case, because this court doesn't know what Superior Court is going to be doing, or whether that order is going to be revoked or modified, or et cetera. So based on that, the city is not requesting a no contact order. The city is requesting that the defendant have no access to weapons, firearms, or ammunition during the pendency of this case, surrender all of those, and have no criminal law violations during the pendency of this case.
All right, I'll hear from defense response.
Yes, Your Honor, we're also asking for PR release, just based on his limited criminal history, and he'll be able to abide by all of those pretrial conditions.
Yes, ma'am.
All right, well, I'm not sure I would suggest limited criminal history, but a lot of it's older. I do have some concerns about the weapons conviction, the dangerous weapons conviction, but I do acknowledge that those are older. The residential burglary's only 5 years old, the assault 4th degree as well. So those are some concerns that you understand, sir. If you don't show for court, the
Yes.
likelihood that your bail would be quite high.
Yes.
I think that is a safe bet for you.
Okay.
That if you don't show for court. So you have an attorney appointed, and I'm going to follow the recommendation with hesitation today to release you, hoping that you're understanding the importance of showing for court. So I will release you on your promise to appear. I'll set a court date for September 9th at 1 p.m. That's going to be a necessary hearing, as we're last seeing you in custody. I've appointed the public defender, and I've granted all the conditions that the city requested. Other than I just added abide by the protection order as, and that way I do understand. I have normally I would be issuing a no contact order, but I also can appreciate that having competing orders gets very confusing, not only for the parties, but for the courts. And so at this time, I'm just going to order that you abide by whatever provisions the current existing protection order, and whether that gets rescinded or modified, that's your order in this court, as well as to follow that order. Does that make sense, sir?
Yes, ma'am.
Please update your address if it changes. Have no criminal law violations. You're to appear at all court dates. And
When will I be released? Sorry.
so that's best answered by your attorney, because it can be a quite lengthy process, but you are being released on our matter today. So the only thing I can promise you is it should be before tomorrow. Okay. All depends on their amount of staff available, etc. Any questions about what happened here today, sir?
No thing, I mean, no, sorry.
Okay. Anything further from either party?
No, Your Honor.
No, Your Honor.
All right. Get some signatures on the form, and then I'll order you be given a copy of your order, which has your attorney's contact information, your next court date, as well as all your conditions of release, sir. Okay? All right, I see the X. I'm going to sign that order. Make sure and show for court, sir, so you can build a history of trust with the court and showing for court. Okay?
I will, all right, thank you.
Perfect. See you in September.
And Your Honor, I don't know if Resnack is present. This is his client.
Oh, okay.
This is, can you pronounce it?
Robert Suhay.
Suhay, Robert Suhay.
Robert Thomas Suhay. All right. I don't see Mr. Resnack on the platform. He did file a motion to continue. Does the city have any additional information?
No, Your Honor. Forgive me, I did not notice that he had filed a motion to continue. Let me just take a quick look at that. City has no objection to the motion to continue filed by Mr. Resnack.
All right, sir, it looks like your attorney has requested a continuance for approximately 1 week. And for further negotiation is what he's articulated in the order. However, it's normally he would be here to represent that. So I apologize on his behalf that he is not present. Did you have an opportunity to speak with him, sir?
Not since last week, but we talked about everything 2 weeks ago.
Okay. All right, so what I'm going to do is, does the city have a calculation for speedy trial as to where we are and what this would mean to reset it 1 week?
Let me take a look at it.
And while the city's reviewing that, if speedy trial allows, I'm going to grant the motion to continue. I'm going to add your attorney's contact information to the order that you will receive today. I'm also going to set an out of custody pretrial date for September 4th at 1 p.m. so that if you are released, you do have an appearance date on your order. And then we're just gonna.
Your Honor, I don't see the speedy trial expiration in the docket. Let me see if I can come up, or we could always ask, I can ask for this be found as an excluded period based on defense motion to continue.
That would be the court's ruling, but without him present.
Understood, Your Honor.
I'd be more inclined, so I'm going to take a look at here for a moment as well, just to see if we can get a rudimentary calculation, just to make sure your rights are protected, sir. I'm not trying to delay you. I'm trying to make sure your rights are protected before we continue, because you don't have your attorney present, and I get nervous to proceed without him.
Okay.
And not address this. Looks like a failure to appear was and a resummons was July 3rd. Looks like we first saw you July 11th. So the court's calculation would be starting July 11th, 8/11, 9/11, probably 9/10, because there are 31 days in July. At least that's how I calculate, folks. Almost 30 years of calculating. I work backwards from 30, 30, and 31. But rudimentary calculation would have us through September 11th. So I think while that would be a quick trial set, eating up 1 week, depending on the findings of the court as far as an excluded period, would still allow enough time for both parties to appear for trial. So I don't think there's prejudice. So that's my ruling at this point. And I'm making a record of that, sir. I'm putting all that on the record. So if your attorney wanted to come back and review the court's findings, he wouldn't have to read the court's mind. He would know exactly why I would allow that, even though your attorney is not present, but has asked for the motion to continue. Do you have any questions about that, sir?
No, I don't, Your Honor.
Okay. City have any further record that they think needs to be made?
No, Your Honor. Thank you.
Okay. All right. I'm going to grant the motion to continue. Although somewhat chagrined at not seeing Mr. Resnack or somebody in his stead, and I'll sign that order you be given a copy of that, sir, and then we'll see you a week from today.
All right, thank you.
All right, take care, sir.
I think that's it.
Mhm.
Thank you.
And then lastly, we have Macos Middleton, case number 24L1545, and I'll defer to the city as I believe they have a motion.
City?
My apologies, Ms. Arnold. Who is this?
Middleton?
Oh, Middleton. Yes, the city is moving to dismiss this charge without prejudice.
All right. I'll grant the dismissal without prejudice, release the defendant, order he be given, he or she, I don't know, order that the person be given a copy of this order and that they be immediately released based on the dismissal without prejudice, which allows refiling if the city obtains more evidence. All right, anything further on the Pierce County Jail matters or for the good of the order, folks?
No, Your Honor.
No, Your Honor, I believe that's everything.
All right. Well, thank you, folks. The court will be in recess and reconvene for the Nisqually calendar.
Thank you.
Thank you.
All right, ready to proceed. And Mr. Resnack, is that your client in Nisqually?
I do believe that's Miss Tolliver. It's hard to tell because the label video court is right across her face, but I believe it is her.
Okay.
Shikari Tolliver, 25L00128 on review, 25L0
Okay.
2500442 on arraignment.
All right. Good morning, ma'am. Your true and correct name is Takari Jamisha Tolliver?
Yes, ma'am. Yes,
And
Judge.
did I pronounce your name correctly?
Yes, Judge.
Okay. And your date of birth, December 19th of 1990?
Yes, Judge.
And do you still reside or receive mail at the 4303 address in Lakewood?
Which address was that?
4303 32nd Avenue South?
No, Judge.
Okay, so you might have an updated address to submit at some point. You can talk with your attorney about that and get that updated. Did you have an opportunity to discuss with counsel the constitutional rights that attach at arraignment?
Yes, Judge.
Any questions for the court about your constitutional rights?
No.
Okay, and I'll turn it over to counsel for entry of plea.
Okay, Miss Tolliver, just, I guess you already said it. Could you state your name for the record?
Takari Jamisha Tolliver.
Okay. And at this time, Your Honor, what we are going to do is waive formal reading and enter a plea of not guilty. I have not had the opportunity to review. This came up. I wasn't even aware of this case. I guess she just got arrested. Came up. I have not had the opportunity to look at a PC statement. So I'm going to request the city kindly supplement the record.
All right, let me see if I can review it. And if not, we'll swear in the city and they can do it. Just depends if nope, I don't have access to it on jobs. Can I swear the city in and they can supplement the record for probable cause statement?
Of course, Your Honor.
All right. Please raise your right hand. Do you solemnly swear or affirm that the testimony you will give today will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Okay. And go ahead.
I'm looking at a report of Officer Patrick Lavers dated July 25th, 2025, which would be today. Stating that Takari J. Tolliver, apostrophe 90, indicating her date of birth, was arrested after she was positively identified during a field show up as a subject who unlawfully entered and remained inside a residence that she had no legal authority to occupy. On 7/25/2025 at approximately 21:54 hours, I responded to a residential burglary in progress at 9320 33rd Avenue South, Lakewood, Washington. Property owner Renee H. Sutton, date of birth included, called 911 requesting police assistance after she and her fiance, Ricardo F. Glimpf, date of birth included, arrived at the above location and observed lights on inside the home and believed it was occupied by an unknown person. As Glimpf entered the house, a female subject quickly ran out of the residence and was followed by Glimpf as she ran down the roadway. Upon arrival, I contacted Sutton, who advised me that Glimpf was last seen chasing the female. Sutton described the female as a black female, approximately 20 to 30 years of age with medium build. According to Sutton, this is her investment property, as most of the time, home remains empty with minimal items inside. Officer Walker assisted me with my investigation by conducting a field show-up with Glimpf, who positively identified Tolliver as the female who was trespassing inside the residence and fled on foot prior to police arrival.
That's sufficient for probable cause. I'll make a finding of probable cause. At this time, I've entered the not guilty plea, waive the formal reading. I've done a direct appointment to the conflict public defender as he was previously appointed on the last case, and I haven't heard a change in circumstances, and also for being in custody. At this time, I'll ask the prosecutor for recommended conditions of release. Mr. Tuninga?
And Your Honor, the city has no objection to the defendant's release on personal recognizance under the conditions that the defendant have no contact with the property in question. That would be that 9320 33rd Avenue Southwest in Lakewood, Washington. I've already entered that in the order, and have no criminal law violations.
All right. And is there agreed release on the review matter as well?
And the city would ask that no action be taken on the review matter and no objection to the defendant's release on that review matter.
Okay.
No objection.
Okay, give me just a moment. So it looks like you'll be released today on your promise to appear in court. I'm gonna choose a court date. Give me just a moment. I believe we had. The conflict date, but I don't remember it. It is here. Okay.
August the 5th.
September 4th.
September. Yeah, that's right. Yeah.
At
I'm sorry.
September 4th at 1 p.m. I'll add that into your order. So, ma'am, I will grant the requested conditions. Did you want me to go through them again? You will get them in writing, but I'm happy to go through them again if you'd like me to. Okay. So you'll get those in writing along with your court date in writing as well as your attorney's contact information in writing. But you are being released today on both matters with a reset to that September date. Any questions about what happened here today, ma'am?
No, Judge.
Anything further from either party?
No, Your Honor.
Nothing defense. No.
All right, I'll just ask the parties to review the pretrial release order for sufficiency, any additions, deletions, or amendments so that it conforms to the oral ruling. And otherwise, I will sign that and order you be given a copy prior to your release. Ma'am, if for some reason you don't get your court order copy or you lose it, you can always stop by Lakewood Municipal Court and ask for a reprint so that you have all that information that I discussed, okay?
Yes, ma'am. Thank you.
All right, you're welcome.
And
Anything-
Your Honor, I would note on the pretrial release commitment, if defendant released under their own recognizance could be checked so that the defendant does indeed get released.
Okay, I did check it on my end, but it's not showing up on yours.
My apologies, Your Honor. I'll hit refresh.
Yeah, it did show up.
Oh, there it is.
Okay.
My
okay.
apologies, Your Honor.
No, that's okay. Sometimes though, I check it and it doesn't show up because, you know, it's technology. So I always want you to state something you're not seeing rather than worry about disrespecting me. I don't care at all about that. I'd rather that the order be accurate and the person be released. So
I appreciate that, Your Honor.
okay. All right. Anything further from the parties?
No, Your Honor.
Okay. I'll sign your order, ma'am, and wish you good luck. And we'll see you at that September court date. Make sure and show up for court, okay?
Yes, Judge. Thank you.
All right. Take care, ma'am. And is that your only matter today, Mr. Resnack, or?
No, we have Mr. Sid Martinez. I am hoping we can bring him up sooner rather than later because I'm actually handling a calendar in King County District Court right now. Somebody's just spelling me for these hearings. That's my apology for Mr. Suhai. The person that came up to spell me was delayed getting here.
All right.
If you need
So
to
just-
know that.
Yep. Just try to let us know, like, by 10 if you're gonna have a complication, then that way we kind of futzed around a little bit, just weren't sure if you were just a few minutes delayed, but we did take that matter last. And then I just made if you want to hear the record that I made.
No, I don't. No, I know what happened. I
Okay.
appreciate
Okay.
that. Yeah, thank you.
All right.
And
All right.
that
And
is him right here. That's him.
okay, I'm sorry. State your client's name again.
This is Derek Sid Martinez, and he is on for two matters. He's on for arraignment on 25L004338 and a review 25L000398.
All right. And is that your true and correct name, sir? Derek John Martinez or Sud Martinez?
Yes, Your Honor.
Okay. And I'm just going to confirm your date of birth is July 23rd of 1987.
Yes, it is.
And you still reside or receive mail at the 9133 Veterans Drive address in Lakewood?
Yes.
Okay. And did you have an opportunity to review with your counsel the constitutional rights that attach when you're arraigned?
Yes, I believe so.
Okay. And do you have any questions for the court about your constitutional rights?
No, not right now.
Okay. All right. I'll turn it over to counsel for entry of plea.
And Mr. Sid Martinez, just so you're aware, I know you are, but you are charged with criminal trespass in the second degree and obstructing a law enforcement officer arising out of an incident that's alleged to have occurred in the city of Lakewood on June 30th, 2025. And I know we talked about this. I'm just making a record, sir. To that, Your Honor, we are waiving formal reading. Entering pleas of not guilty on both counts. And I'm in the same situation. I have not had the opportunity to look at a PC statement.
All right. And asking for direct appointment?
Yes, Your Honor. Sorry. Yeah.
All right. And the city's already under oath. Is the city prepared to offer a probable cause statement?
Yes, Your Honor.
Okay, go ahead, please.
I'm looking at the report of Officer Jeremiah Futch. Let me just take for a moment that I'm looking at the right cause number. Yes, I'm looking at the right cause number. So that report by Officer Futch was signed on, or was dated July 6th, 2025. On June 30th, 2025, I was working patrol for the Lakewood Police Department. At approximately 1750 hours, dispatched by South Sound 911 to 9200 Veterans Drive, Southwest Lakewood. Upon speaking with a reporting party on the phone, he stated that he witnessed a man later identified as suspect Derek walking down the street, cross through the intersection, and start following a couple of underage girls.
That's not true. I have no idea what that means.
Sir, I understand you might dispute it. It's just a probable cause finding, not making any decisions about the truth of the matter or guilty or not guilty. This is just a probable cause statement, okay?
I'm sorry, I apologize.
That's okay. Go ahead, Mr. Tuninga.
I arrived in the area and spotted Derek walking eastbound on Veterans Drive towards the roundabout. I activated my overhead lights and contacted a subject stop on Derek. I explained to him the reason for the stop and that he was being detained while I conducted an investigation. Derek denied following girls today and also the events of the day prior. He was agitated and uncooperative. He told me I needed probable cause to detain him. Again, I explained that I needed probable cause to arrest him, but only reasonable suspicion to detain him. I told him repeatedly that he needed to identify himself or potentially face obstruction charges. Again, he refused. I called for additional units to assist in order to de-escalate the situation. After Officer Tapansa and Pingle arrived, Officers Tapansa and Pingle said that they knew him and that he has a history of burglaries and criminal trespasses in Lakewood. This time, Derek provided an incomplete last name of Martinez. Officer Tapansa attempted to look up Derek unsuccessfully. Sergeant Moody arrived on scene and was able to identify him.
All right, thank you. I'll make a finding of probable cause at this time for charges to go forward. And if the defense wants to dispute that, they can file a motion. Okay, and I've entered the not guilty plea, waived the formal reading. I'm turning now to the city for recommendation on conditions of release.
And Your Honor, the city has no objection to the defendant's release on personal recognizance under the conditions that he have no contact with the property located at 9305 Highland Avenue Southwest and have no criminal law violations during the pendency of this case.
No
All right,
objection.
Ben. Okay.
Okay.
And is city taking any action on the review matter or agreed release on that matter as well?
Agreed release on that matter, Your Honor.
All right. So, sir, they're recommending your release today, so you understand you appearing in court is an opportunity to show that you can be released and show for court. You understand, however, if you don't show for court, you do have some prior warrant history, and you know the other history that I'm looking at specifically back in 2019 and 2020 that would probably lead to some pretty high bail warrant. So if you show up for court, then you don't have to worry about that.
I understand. I appreciate it, and
Okay.
thank you.
I'm just making you aware. Otherwise, I'm going to set your court date out of custody for September 4th at 1 p.m. That will be at the Lakewood Municipal Court. You will get paperwork, which will have your court date, your conditions of release, as well as your attorney's contact information. Do you need me to go through the conditions of release again? You will get them in writing, but I'm happy to go through them again if you'd like me to.
I don't want to hold anybody up. But
We just have that address one more time.
what's
Pardon me?
that?
The subject property that you're supposed to
Oh,
say.
9305 Highland Avenue Southwest.
Okay,
is the-
no, yeah.
Okay,
Yeah,
the
I understand. Conditions of release. I appreciate it.
And otherwise, appear at all your court dates, have no criminal law violations, update your address if it needs changing, use your true and legal name and date of birth, okay?
Okay.
And let's see, I am updating that court order. I'm going to ask the attorneys to review the pretrial release order for sufficiency, any additions, deletions, or amendments. Let the court know, and otherwise I will order that you be given a copy of the court order as well, sir. If for some reason when you're released, you're not given a copy or you lose it, you can stop by the Lakewood Municipal Court during office hours and get a reprint so that you have your attorney's contact information, all your conditions, and your court date, okay? Any questions about that, sir?
No. Thank you, Your Honor.
Okay. Anything further from the attorneys on these matters?
No, Your Honor, I'm just having trouble refreshing like counsel was a minute ago. No, it looks okay. Thank you.
All right.
No, Your Honor, no objections from the city.
Okay, I'm going to sign that order and order it be served on Mr. Sud Martinez. And it's going to take me a minute because I too am having trouble refreshing the order. Here we go. I don't know if it deleted everything. Let's see. Nope, looks like it's all intact. Okay, we'll sign that order. Wish you good luck, sir.
Okay, thank you.
See you in September.
All right, see you.
Get in touch with your attorney.
I will. Thank you. I appreciate it.
That's a
Take care.
song, isn't it? See
Take
you.
care, you guys.
All right.
Okay, that's it, Your Honor. May I be excused?
Yes, you
Got a room
may.
full of people looking for me over there. Thank you. I appreciate it.
Take care. And then I believe Ms. Arnold did she need a breakout room or did she already have success with that? Well, we don't have anybody yet, so can you give us your name, please?
Jeanette Sullivan?
Jeanette Lee Sullivan?
Yes.
And I'm sorry, Ms. Arnold, did you need a breakout? I can't remember. I saw the message briefly. Was it with this individual?
Yes, Your Honor. These
Okay, perfect.
there's a couple that were added while I was in PCJ, so I will need
Okay.
breakout rooms.
That's fine.
Thank you.
All right. We'll be in a brief recess and ask the court to put Ms. Arnold in the breakout room. Are we ready to go back on the record with your next matter, Ms. Arnold? Okay. And
Yes.
remind me of your client's name.
Jeanette Sullivan, case number 25L4429.
All right. Good morning, Ms. Sullivan. Can you hear me, Ms. Sullivan?
Yes, I can, Your Honor.
Okay, perfect. And I'm just going to confirm your true and correct name is Jeanette Lee Sullivan.
Yes, Your Honor.
And give me a second. Computer's just updating. Your date of birth, August 19th of 1985.
Yes, Your Honor.
And you still reside or receive mail at the 864 address in Tacoma?
No, I don't.
Okay, so you may have a new address to update.
No, I don't.
Right now you're between addresses.
Yeah.
Okay, I understand. And did you have an opportunity to talk with the attorney about the constitutional rights that attach at arraignment?
Yes, Your Honor.
Did you have any questions for the court about your constitutional rights?
No, Your Honor.
Okay, and I'll turn it over to counsel for entry of plea.
Yes, Your Honor, we'll waive a formal reading, enter a plea of not guilty, and stipulate to probable cause for today's purposes only. And we're asking for an appointment based on unemployment.
All right. I will waive a formal reading of the charge of 1 count of theft, enter the stipulation of probable cause for purposes of setting conditions, and a not guilty plea. At this time, we are going to turn to the city. They're going to make their recommendation on conditions of release, and then I'll allow you and your attorney to respond. And by the way, I did do a direct appointment to the public defender based on the request. So you now have an attorney appointed on your case. Mr. Tuninga?
City has no objection to the defendant's release on personal recognizance under the condition that she have no contact with Walmart stores in the city of Lakewood and have no criminal law violations during the pendency of this case.
I'll hear from defense.
Yes, Your Honor, defense is in agreement with that. We're requesting PR release. We would like to acknowledge that, yes, there are 4 active warrants, but I have spoken with her and she knows how to go about taking care of those warrants that she was not aware of. And we would also like to mention that this is an allegation of stealing soap and butter from a store. So for those reasons, we're asking for PR release. Thank you.
All right, thank you. And I will grant the PR release based on the recommendation and records made. I'll set you for September 9th at 1 p.m. at the Lakewood Municipal Court. I will grant those conditions of appearing at all court dates, having no criminal law violations, updating your address when you get one, and using your true and legal name and date of birth. And I'm sorry, was there a victim business?
Walmart, Your Honor.
Walmart, got it. I will add that. And you're not to have any contact with Walmart in Lakewood. Do you understand your conditions of release, ma'am?
Yes, ma'am.
Okay. I will order that you receive a copy of your order before you're released today. That will have your court date on it, your attorney's contact information, and all your conditions of release. Okay, so that paperwork should have all that information in there, and I encourage you to reach out to your attorney. If for some reason you don't get that paperwork or you lose it, you can always stop by Lakewood Municipal Court and get a copy of it so you have all that information at your disposal. Okay, any questions for the court?
No, thank you, Your Honor.
All right, anything further from either party? Just ask you to review the pretrial release and let me know if any additions, deletions, or amendments.
Looks good to me, Your Honor.
Defense is signed.
All right, I'll sign that order. Order you be given a copy, ma'am, and then wish you good luck and we'll see you in September.
Thank you.
Take care.
Thank you, Your Honor.
And you're all good. You can go ahead and walk out. Thank you.
All right. Can you please state your full name?
Benedetto.
All right. And counsel, did you need a breakout with Ms. Benedetto?
I do, Your Honor. Thank you.
All right. You're going to receive an invite to join a breakout room from your attorney. So if you look at the screen, you may have to have somebody from the jail help you join, but there should be an opportunity to join on the screen.
I don't see anything. I'll get some help.
Okay. Okay. Court's in a brief recess.
Can you help me? Thank you. Step away, like invite to join to break all the way. It's just normally they will pull it up and we just click the button to go on the break room. Yeah, I don't know.
If it's not coming up, if you can click more and then breakout rooms. I don't know what your screen looks like. There might be breakout rooms on the bottom.
No. Oh. There you go. That's one. Yeah. In room 1 or room 2?
1 is just fine. Thank you.
Look who's there, everything that's neat.
All right, we're back on the record for the Nisqually jail calendar for the Lakewood Municipal Court. And this is Gail Ann Benedetto. Is that your correct name, ma'am?
Yes, ma'am.
Great. And I'm just going to confirm that your date of birth is May 8th of 1984
Yes.
and that 101 Crestwood is still a good mailing or residential address for you?
No.
No. Are you between addresses right now?
No, I have my own address.
Okay, you have a new address. Okay. Well, we'll allow you to update that through your attorney. I'm going to turn to the constitutional rights and ask if you had an opportunity to review the constitutional rights that attach an arraignment with the attorney.
Yes, I know my constitutional rights.
Okay.
But are you upholding your oath to them today?
I'm sorry, I didn't hear you.
Are you honoring your oath to those constitutional rights today?
Yep, I honor them every time I show up for work. So I just want to make sure that you have reviewed them, but I appreciate that.
Thanks.
Okay, and at this point, I'm going to turn to counsel for entry of plea on the arraignment matter 25L004426, one count of controlled substance. Go ahead, counsel.
Yes, Your Honor. So now that Ms. Benedetto has acknowledged that she understands her rights, I would be comfortable proceeding with arraignment. So we'll waive a formal reading of the criminal complaint, ask the court to enter a plea of not guilty, and stipulate to probable cause for today's purposes only. And we are asking for direct appointment on this new criminal charge. It appears that on the prior case that she was told to hire private counsel, but we're asking for appointment on both and that the two track along together.
All right. I will grant the request for direct appointment on both matters and turning specifically to the case ending in 4426. I'll enter a not guilty plea, waive the formal reading, enter a stipulation for purposes of setting conditions. At this point, I'm going to turn to the city. They're going to make their request of conditions of release. Then I'll allow you and Ms. Arnold to respond. City?
City has no objection to the defendant's release on personal recognizance under the condition that she have no access to alcohol, cannabis, or non-prescribed drugs and have no criminal law violations during the pendency of this case.
All right, Ms. Arnold.
No objections, Your Honor.
All right, ma'am. You will receive copies of the conditions of release in writing. However, I will go through them again right now if you'd like me to.
I think I just said no alcohol, no drugs, no police contact or anything like that.
Okay, so I just give you an opportunity if you want me to go through them again, but otherwise, I'm ordering that they be given to you in writing as well as your attorney's contact information and your order for your next court date. And I'll tell that to you in just a moment here as I pull that up. When I'm not looking at you, ma'am, I'm just looking at the court order that I'm creating that then will be printed for you. Okay. So let's see, that will be September 9th at 2 p.m.
September 9th, 2 p.m.
Right. And you will receive that in writing on your court order along with your attorney's contact information and your conditions of release. However, if for some reason you're not given that paperwork or you lose it, you can always come to the Lakewood Municipal Court and ask for a printout of your court order. And that way all that information will be available to you. Does that make sense?
It does.
Okay. All right. Any questions about what happened here at this hearing, ma'am?
No.
Okay. Anything further from the parties? I'll ask you to review the pretrial release. Let me know if there are any additions or deletions or amendments, and otherwise I will sign once it's approved. And that same order we're talking about, ma'am, is the order that I'm wanting you to receive before you're released. Okay?
Yes.
All right.
Looks good to the city, Your Honor.
All right. I'll sign that order, and ma'am, we will look forward to seeing you in September. Okay?
Thank you.
All right. Good luck, ma'am. Take care.
I can leave now.
You can head out that door and they can send the next one in. Thank you for asking.
Thank you.
Take care.
Yes.
All right, we're back on the record for the Nisqually calendar for July 25th, 2025. And Ms. Arnold, could you please introduce your client?
Yes, this is Natasha Burris, case number 23L 000101. And then there's another matter as well that is 21L 001201.
All right, good morning. Well, good afternoon, I guess now, Ms. Burris.
Good afternoon to you also, Judge.
All right, nice to see you. And I'm going to confirm some information. I'm just going to ask, is your date of birth August 15th of 1989?
Yes,
Okay. And do you still reside or receive mail at the 10814 address?
yes,
Okay, perfect. And did you have an opportunity to review the rights that attach at arraignment with counsel today?
yes.
And did you have any questions for the court about your constitutional rights?
No, I did not.
Okay, so this time I'll turn over to the parties as to how we're proceeding today.
Your Honor, so I believe that this case is in pretrial, and I'm just double checking now. Yes. These matters are at pretrial and the parties have come to a resolution. Ms. Burris does wish to plead guilty to 2 charges under the 0101 case number. And the city is agreeing to dismiss the matter ending in 1201. I have gone over the guilty plea in its entirety with Ms. Burris, and I believe that she understands it, and that she understands that she's waiving important trial rights by entering into a guilty plea.
All right. So, I'm just going to clarify. So, the pleas are only on 2 of the counts under 23L000101, and the matter in its entirety under the case ending in 201 is being dismissed pursuant to successful entry of the plea?
Yes, Your Honor, that's correct.
Okay.
Yes, Your Honor.
Great. Just so I understand before we go forward. And any record from the city?
Your Honor, this is very much a plea and close recommendation from the city. It's my understanding that she has served 9 days in custody already. And so the city's recommendation is only for that 9 days.
All right. And any further record, Ms. Arnold? Otherwise, I'll start my inquiry.
No, Your Honor, other than the fact that it's based on the specific facts of the case and believe that it's appropriate.
Okay, thank you. And I already confirmed your name, ma'am. And so I'm confirming you're 35 years old and you also completed 2 years of college. Is that all correct?
Yes, it is.
Okay. And is it your understanding today that you're asking the court to accept a plea of guilty on 1 count of theft and 1 count of assault 4th degree? Is that your understanding?
Yes,
You understand that each of those charges carries a maximum penalty of 364 days in jail and a $5,000 fine.
yes,
And you understand that there were significant constitutional rights that attached when you were arraigned on those matters. But by pleading guilty today, you are giving up all those rights except for your right to an attorney. Do you understand that?
yes, I do.
Okay. You understand also that there is a plea agreement, and it was alluded to by the prosecutor and the defense that this was a plead guilty and close file upon credit for time served. But you understand I don't have to follow that recommendation. What that means is I can impose anything up to the maximum if I decide that I believe that's appropriate. You understand that?
Yes, I do.
All right. And did your attorney review with you possible collateral or immigration consequences that could result from pleading guilty?
Yeah.
Any questions for the court about those?
No, I don't.
Okay, I'm going to read you a statement. You tell me if this is your statement. On January 8th, 2023 in Lakewood, I did wrongfully obtain or exert unauthorized control of the property of another with the intent to deprive them of that property at the Chevron. And on that same date, I did make harmful or offensive contact with you, Young. Is that your statement?
Yes,
How do you plead to 1 count of assault in the 4th degree? Guilty or not guilty?
guilty,
And how do you plead to 1 count of theft in the 3rd degree? Guilty or not guilty?
guilty.
Anyone threaten you, pressure you, coerce you in any way into pleading guilty today?
No, Your Honor.
Are you doing so of your own free will?
Yes, I am.
Okay, I'll accept the pleas as knowingly, voluntarily, intelligently entered. I'll find there's an adequate factual basis to support the pleas. Bases to support the pleas, and I'll find that she's been advised of the nature of the charges, the consequences of the pleas, and I do find you guilty I just checked served on defendant since I didn't have a signature and just letting the parties know for the record. Ma'am, you have a right to make a statement prior to your sentencing. You don't have to make a statement, but you have a right to do so. I'll hear from the parties and then I'll ask you if you have anything you want me to know. But before I turn to that, I'm going to first turn to the order of dismissal, since I have a tendency after the judgment and sentence to forget there's anything else to do. And since the pleas have been entered at this time, it is city's motion to dismiss with prejudice all the matters under 21L001201. Is that correct, Mr. Tuninga?
Yes, Your Honor. City is moving to dismiss with prejudice pursuant to negotiations.
All right, I will grant that motion to dismiss, and I will sign that order and the release on any of those charges, as well as a dismissal with prejudice. Okay, turning to sentencing, I'll hear from the city first, then defense. Go ahead.
Your Honor, this is very much a plea and close recommendation by the city, just that the defendant has served 9 days and the city is only requesting credit for those 9 days, and the case should close. It is not asking for any form of financial obligations.
All right. Thank you. And I'll hear from defense.
Yes, Your Honor. Defense is in agreement, again, based on the specific facts of the case. And also I'd like to make a record for her ability to pay. She is on Social Security, so her ability to pay is very limited. Thank you.
Understood. All right, ma'am, is there anything that you want the court to consider as it regards your sentence?
Yeah, because I've been doing like mental health counseling instead for my disability so that I'm not doing stuff like that, and then doing substance abuse treatment so that I don't go down that wrong path and doing stuff that I can't remember and causing problems.
Right. Well, it sounds like you have some great ideas as to how you can move forward. And with that prior education, I imagine that helps you have a clear framework of where you want to go. Now it's a matter of getting there, right?
Yeah,
Which is easy to say and always more difficult to do.
exactly.
All right. Give me just a moment as I'm going to, if the parties don't mind, I'm going to delete the current judgment and sentence, and I'm going to upload one that only has the one set of only has the charges that I'm sentencing on, and that way it's just a little bit clearer because it makes me nervous. So I'm gonna, oh, thank you. I was having trouble deleting it, I think, because I didn't upload it. Okay. We're gonna start over here. I love it when someone helps me. Thank you. All right. I've had an opportunity to review your history and hear the comments of the parties, and I am going to follow the recommendation as outlined by the parties. So you don't need to worry that I'm going to order something different. And I'm just filling out that order now. Since I deleted the other one, it's always going to take me a little bit longer. Just bear with me here. Impose on the theft, 3rd degree, 9 days. And credit for 9 days served. I'll make a finding of indigency based on the record made and not impose costs and assessments. So you should be released on that matter. And I'm presuming that the 9 days was intended to be concurrent on the 2 matters that she pled to, just to be
Yes,
clear.
Your Honor.
All right. So I'll impose the same 9 days. I will mark that concurrent. Take no jurisdiction, make a finding of indigency on that one as well. And credit for 9 days served. No imposition of fines and costs based on a finding of indigency. As far as the other matters under 101, those will be dismissed with prejudice pursuant to the plea agreement. And you will be released on those matters as well, of course. almost done with your judgment and sentence, and then I will ask the parties to review it, make sure I didn't have anything that I overlooked, any additions, deletions, or amendments. But ma'am, you've served your time. Your cases are going to close. And I need to add that on the guilty pleas, and I'll ask the parties to review the judgment and sentence for sufficiency. Any questions about what happened here today, ma'am?
No, Your Honor.
I'll order you be given copies of all the paperwork of the guilty pleas you signed and your judgment and sentence, just so you have that for your records, okay?
Okay.
All right, anything the court overlooked or is inconsistent with the oral ruling, parties let me know.
No, Your Honor, and the city has signed off on that judgment and sentence.
And defense has as well.
All right, I'll sign that order. And ma'am, I wish you luck, and more than luck, I wish you strength and courage to pursue a different lifestyle. So I hope you get there. I know I see you've been through some life.
Yeah.
Right? You've been through some life and you have a chance, but you also, with an attorney appointed on your case, they have a lot of resources and ideas of how people can have success. So I'd strongly encourage you to use any resource that you have at your fingertips to pursue that new life, right? So if I have an expert and I know their number, I'm going to call them. So strongly encourage you to reach out to any support that you could have so you can grab onto that new life and fight to have it, right?
Yeah.
All right. Any questions for the court, ma'am? Any questions?
Oh, sorry. No.
All right. Anything further from either of the attorneys?
No, Your Honor.
Nothing from the city. Thank you.
All right. And my understanding is Gumatau is a refusal at this point. That's my understanding. So we're not going to hear that case. That'll be reset to the next available calendar. Anything else? The clerk will let me know if I need to do anything on that, but I don't believe so. Just noting the refusal and the reset. And then anything else for the good of the order on any cases or anything?
No, Your Honor.
All right.
Your Honor, it's my understanding we need to establish probable cause on Mr.
There we-
Gumatoto's new charge. So let me pull up the
There we go.
reports for that.
Okay.
I finish.
You're done. Thank you, ma'am.
All right, you guys have a nice day.
You as well. All right, so that will be the cause number ending in 428 from yesterday. And I already swore the city in and I don't have access to the probable cause statement. So if I could just remind you under oath and ask you to establish probable cause, Mr. Taninga.
Of course, Your Honor. Unfortunately, I was hasty in getting ready to pack up, so I closed the program that permits me access to that. So let me just pull it up real quick. I'm half the way back.
All right. And Ms. Arnold, you're welcome to stay and possibly object, or you can be free to go. It's up to you.
No objection, Your Honor. I'll just go ahead and go. Have a good weekend, guys.
All right. Take care.
Take care, Miss Arnold.
This is the Butler County, Kansas first appearance docket of July 25, 2025. I'm David A. Rickey, District Judge. First case that clerk will call on this docket is State of Kansas versus Isaiah David Dyka Salzman. Case number 2025 CR 337. There's an individual seated at the detention center Zoom location. Are you Mr. Dyka Salzman?
Yes, sir.
All right. Court has before it a charging document which alleges in count 1 violation of a protective order, a Class A person misdemeanor, punishable by up to a year in the county jail and up to a $2,500 fine, or both. How do you intend to plead to this, Mr. Dyka Salzman?
Guilty.
Excuse me?
Guilty.
All right, you understand the penalties that I just read off to you.
Well, I would have to, I don't have an attorney or anything.
Okay, then I think it's better if you enter a plea of not guilty at this point.
Okay, yes, sir, not guilty.
And obviously you want the advice and assistance of counsel.
Yes,
Are
sir.
you afford to hire your own lawyer?
No, I can't. I'm not employed at this.
All right, the court will appoint Darren Patterson to represent you. We'll set another court date on Judge Webster's calendar for October 6th, 2025 at 8:00 a.m. You will fully participate by Zoom at that time. October 6th, 2025, 8:00.
Yes, sir.
I know that you've already got a bond set in this case, or at least one that was recommended, should have been on your warrant, which I presume you were picked up on an active arrest warrant, Mr. Dykus Salzman?
Yes, sir.
Okay. Bond is currently $7,500, cash or professional surety required.
Yes, sir.
With a strict no contact or no communication order with the individual who's contemplated by the civil restraining order.
Yes, sir.
Okay, that's also going to be a requirement in this case. So you've got two restraining orders concerning the same individual. All right. Court noting that Jared Regier appears on behalf of the state. Do you have any other recommendations or matters to bring before the court regarding this case?
Your Honor, the state's position is that $7,500 cash surety is highly appropriate. It is the state's understanding that this is a defendant with 5 other Butler County cases, at least 3 involving the same victim as the current case. I'm not sure if the court wants to make any orders concerning GPS monitoring or pre-trial court services reporting at this juncture, but I'll defer to the court on those points.
The court does not. What I want to make sure is 2 things, Mr. Dykus Salzman, that you leave this alleged victim alone.
Yes, sir.
And you show up for court when you're supposed to.
Yes, sir. I'm not bonding out. I'll be here.
And Your Honor, what
you seek to have your bond reviewed by your assigned judge, Judge Webster, at any point in the future, just so you know that, Mr. Dykus.
Okay. Thank you.
All right. What, Mr. Regier?
Your Honor, I don't know if this has any bearing on the court's orders for today, but per my duty of candor as an officer of the court, at least 3 of those cases do appear to be scheduled before Magistrate Judge Webster next Monday.
There's 3 other cases involving the same individual? All right. Well, I have no problem with having this case called along with the others. What's the date and time for his next appearance on those cases?
Your Honor, it appears to be July 28th at 9 a.m. If I misspoke, I apologize. One of those matters does appear to be a traffic matter. However, the other 2 cases on that same docket appear to involve the same victim as the current case.
All right. Thank you, Mr. Regier. We will have this case at least looked at by the assigned Judge Webster, July 28th at 9:00. That's your new appearance date and time in this case.
Okay.
All right.
Thank you.
Very well. If there's nothing further, that matter will be in recess. We'll move on to another case. Are you James Patrick Squire?
Yes, sir, I am.
This is State of Kansas versus James Patrick Squire, case number 2025 CR 338. Jared Regier appearing for the state and Mr. Squire appearing from the jail Zoom location. Do you have a copy of your charging document before you, Mr. Squire?
Yes, sir.
Count 1 alleges possession of methamphetamine, a level 5 drug felon. Count 2, possession of paraphernalia for use, Class B, non-person misdemeanor. Count 3, driving while license is suspended or canceled, a Class A non-person misdemeanor. And count 4, failure to register a vehicle, an unclassified non-person misdemeanor. Since a felony charge is involved, you will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Chad Crum. Judge Crum's next docket for that purpose would be August 11, 2025, 2:30 p.m. You must fully participate in Judge Crum's docket at that time. August 11, 2:30 p.m. Mr. Squire, do you have the financial resources to hire your own lawyer?
No, sir.
Is that because you're not working or?
I could be working if I was out with my cousin, but Right now, I'm in here. I'm not working.
All right. Do you have other holds on you besides this case?
No.
Okay. What kind of work do you normally do?
I help him like rebuild trailers and stuff, like welding and like ripping old floors out, putting new floors in, and repainting. And
Well, I don't see really the regular and consistent income that would allow you to hire a lawyer for a case like this. The court's going to find you at least partially indigent and will appoint a lawyer to represent your interest. James Watts will be appointed. Mr. Regier, recommendation regarding a bond here?
Your Honor, if the court is prepared to order GPS monitoring this case, the state is prepared to recommend a $2,500 cash or surety bond subject to all standard conditions with special emphasis on no contact with illegal drugs. Besides the nature of the charges currently before the court, this is a defendant who appears to have at least 6 prior failures to appear, most recently in March of this year, at least 6 prior misdemeanor convictions for driving while suspended and various property convictions if the court considers it relevant. Additionally, the state understands this is a defendant who has had 3 cases recently before this court that were either dismissed pursuant to plea agreement or proceeded to sentencing within approximately the last year.
All right, Mr. Squire, you apparently have quite a record of non-appearance in court.
yes, that's. I will show up for this one. I promise.
Okay, I've made a promise a lot of things, a lot of times, Mr. Squire.
Yes,
People
sir,
don't follow through with their promises. So you can understand why I don't necessarily take that at face value.
I do understand.
Where do you live, Mr. Squire?
In Beaumont with my father.
Squire is a prominent name in Beaumont, Kansas.
Yes, sir.
All right, the court's going to set bond at $2,500, cash or professional surety required. Court is considered, but declines to impose a GPS requirement. I'd rather have you out working and doing something positive while you're out on bond, Mr. Squire. But
Yes,
you
sir.
still need to show up in court for this case when you're ordered to do so. And that was before Judge Crum, August 11, 2:30 p.m.
Yes.
All right. Anything further at this time then, Mr. Regier?
There, Your Honor.
Any questions, Mr. Squire?
No, so I can bond out today for $2,500
Correct.
cash surety.
Yes. On this case, anyway. Yes.
Okay.
All right. I think that concludes the Squire matter. For now, we'll move on to another matter.
Thank you.
Mark James Alfaro Sr.
Yes.
All right. I have one case, State of Kansas versus Mark James Alfaro, case number 2025 TR 462. Further, Mr. Alfaro, it would appear that you were picked up recently on a drug paraphernalia charge and possibly possession of opium, narcotic, or a certain stimulant. However, at this point, the state has not filed charges in relation to the drug incident. You do have this other case currently pending in court on traffic matters. Apparently, the charges there are failure to give notice of change of address or name on your driver's license, which would be an unclassified misdemeanor, and vehicle liability insurance violation, which would be a Class B misdemeanor punishable by up to a $1,000 fine, minimum fine $300, and up to 6 months in the county jail. The unclassified offense carries penalties of up to 30 days in the county jail and up to a $1,000 fine or both. You understand these things?
Yes.
Okay, regarding the traffic case, what are your intentions?
The traffic case.
You were supposed to have taken care of this by now. I see that you were given a ticket rather than arrested.
Yeah.
We're going to have this taken care of by June 18th, and we're way beyond June 18th.
I do have the proof of insurance. I forgot to file it because shortly before that I had to prove it again, and I took it in, and I just didn't take it in the second time for the different offense. So that was my fault. I can take it in there today and show them today that I have the insurance. I had the insurance at that time.
Okay, well, you probably have to be out of jail first.
Well, yes, sir.
Okay. And as far as this other charge of the driver's license violation,
Again, when I got picked up for something different, I had to prove change of address and the insurance. And then the second time, it should already be on there. It should have already been in their file that it was changed because I'd taken it in before, but again, I can prove that as well.
all right. Mr. Regier, do you have a traffic docket date to provide this court with?
One moment, Your Honor. Your Honor, the state understands that the Judge Webster traditionally hears traffic cases on Wednesday morning at 9 a.m. It does appear there is one being held next week, although there does appear to be a high number of cases on that same docket.
All right. Is there a docket in the near future and that would have fewer cases that I could offer this defendant?
Your Honor, it does appear that Judge Lee is holding a docket next Friday at 1:30. That is August 1st, and the state understands that such cases are traditionally heard by Judge Lee.
All right. I will utilize that date. I'm going to set another court date for you, Mr. Alvaro, on this traffic case for August 1, 2025, 1:30 p.m. You are ordered to appear at the Butler County Judicial Center in El Dorado, Kansas, and no other location. Bring whatever paperwork you have that would support any of your claims regarding these two traffic matters. Perhaps the insurance or maybe even the driver's license charge could get dismissed, but you're going to have to bring your documentation with you on that day, August 1 at 1:30. For now, I'm not going to appoint counsel. We have some optimism here that maybe this can be resolved without that, unless you want the court to consider appointment of counsel.
No, I don't need counsel, sir.
All right. So bring it to the Judicial Center. Make sure you're on time, 1:30 p.m., August 1, 2025, before the Honorable Joe Lee to further address the matters in your traffic case. I'll need to set a bond to secure your appearance for that. I'm a little concerned here, Mr. Alfaro, that you didn't take care of business by the court date that you were given when you got this ticket. It's like you just blew it off.
I didn't. I had a lot of things going on. I really didn't intentionally blow it off, but I do understand your concern. But I will be there. There's no question about it. I will be there on the 1st.
Court will set bond at $750, cash or professional surety required. So with the assistance of a bondsman, you can get out, Mr. Alfaro.
Okay.
$750 cash or professional surety. Court date August 1, 1:30 p.m. Where it's not appointing counsel at this time. And further action can be taken in the traffic case at that time. If for whatever chance you receive a summons from the county attorney's office regarding this drug situation, you'll need to respond appropriately to whatever court date and time that summons tells you to appear at. Okay.
I understand.
All right. Anything further regarding Mr. Alfaro at this time, Mr. Regier?
Your Honor, is the court ordering that the defendant's requirement that he appear in person for the next docket be made a condition of the bond in this matter?
Yes.
Very good, Your Honor.
We had to appear at the Butler County Judicial Center in person.
Very good, Your Honor.
Any questions about that, Mr. Alfaro?
No, sir.
Okay. And if there's nothing further, the Alfaro matters will be in recess. We'll take up a different case.
Thank you, Your Honor.
All right. Benjamin Parmenter III.
Yes, yes, sir.
Okay, the case I have is State of Kansas versus Benjamin Lee Parmenter III. It's case number 2024 CR 356. Jared Regier appears for the state for this case. Mr. Parmenter from the jail's Zoom location. This is a post-sentencing matter docket notes from Judge Satterfield back in November indicate that you were apparently sentenced on attempted residential burglary, a level 9 felony, received a 14-month DOC sentence, and placed on probation with community corrections. Court has before it a warrant to show cause alleging probation violations. Apparently, you received some tickets in Leon for various traffic offenses and was eventually convicted of driving while suspended in that municipal court. Apparently, you were arrested, according to this, in June by the sheriff's office for violation of a protection order.
Yes, sir. I'm just waiting on
And another arrest on July the 14th for fleeing and attempting to elude and other violations.
Yeah, I haven't been to court on those ones yet.
Your next court date's in September on that.
Yes.
You're out past your curfew, according to this. You continue to have contact with a Patricia Lentz, apparently someone that you're not supposed to have contact with. And you hadn't completed your batterer's intervention program. All is alleged by Ms. Stanfield from the Community Corrections Department.
Yes, I'm still in the programs. I'm still taking my medicine. I'm in I got case management. I got all those still going. I just trying to get out of jail so I can get back to work and take care of my family. I got 7 kids out there.
All right, Judge Satterfield, your assigned judge, has set a bond at $10,000 cash or professional surety. She has ordered a GPS requirement, so you wouldn't be required as part of your bond out procedure to have a GPS monitor monitoring your location. You're also not to have any contact or communication with this Patricia Lentz.
Yes, sir.
Condition of a bond in this case. I'm not inclined to modify Judge Satterfield's bond. I consider your continued violation of protection orders and restraining orders issued by courts to be quite disturbing, Mr. Parmenter.
Yes, sir. Can you help me out at least lowering the bond some so my family can get me out? So
I just said I wasn't going to do that.
Okay.
So I think the court's answer will be no, Mr. Parmenter. You can always apply to the judge that made the original order, your assigned judge, for relief on the bond, but this court's not inclined to grant it based on what I have before me.
Okay, because I seen Judge
cash assured.
I seen Judge Satterfield Wednesday.
You saw her Wednesday?
Yeah.
Okay.
Your Honor, if I may.
You may.
Your Honor, there does appear to be another pending request for revocation in Butler County 24 CR 284 involving the same defendant. Based off my notes, it would appear that is currently scheduled before this court, before Your Honor, on August 8th.
All right. I need to make sure you keep that court date. For sure, Mr. Parmenter.
Okay.
So you apparently saw Judge Satterfield on her first appearance docket for my case. Now I'm in return. I'm seeing you on her case on this docket.
So altogether, my bond's what, 60,000? Because she put a bond for 50, and now you got a 10,000.
That's how it would add up, Mr. Parmenter.
Okay. Thank you.
Okay. Now, as far as appointment of counsel, who was your lawyer before? Watts?
I think it was Watts and Josh Andrews. One of those two. I'm not 100%.
It does appear that the attorney that was on this case at the time you were sentenced was James Watts.
Okay.
So I will reappoint him to represent your interest in this case. On Judge Satterfield's warrant to show cause docket, September the 19th at 2:30.
Okay.
So your court date with Judge Satterfield is September 19th, 2:30 p.m. You must appear, if you make bond, at the Butler County Judicial Center in El Dorado and no other location, Mr. Parmenter.
I didn't hear you. I didn't.
You have to appear at the Judicial Center.
Okay.
Okay. In court.
Okay.
You have to appear there in person if you make bond on this case. And this case that's currently before us is September 19, 2:30 p.m. You also must report to your officer as that officer directs if you make bond between now and the time of court. And again, there is a GPS requirement in this case.
Okay,
All right.
so I gotta be put back on the GPS before I can get out?
Yes.
Okay, okay.
All right. I think we've covered attorney's appointment, setting a court date, and review of his bond situation. Anything else, Mr. Regier?
Not on this matter, Judge.
Very well. Then the Parliamentary matter will currently be in recess.
Thank you. Hang it. Yuri?
I'll start.
Jeremiah Yergin?
Yeah.
This is State of Kansas versus Jeremiah Joe Richard Yergin, case number 2025 CR 340. Jerry Regier appearing for the state of Kansas. Mr. Yergin appearing from the Butler County Jail Zoom location. Mr. Yergin, I will inform you that you have a charge in this case number 25 CR 340 of aggravated burglary, a level 4 person felony. And count 2 is theft, a class A non-person misdemeanor. Since the felony is involved, you will not be pleading at this time. Rather, the court will establish a preliminary hearing setting before your assigned judge. The judge assigned in this case is the Honorable Charles M. Hart. Judge Hart's next docket for that purpose would be August 27, 2025 at 2:30 p.m. August 27, 2:30 p.m. I'm also going to order you to appear at the Butler County Judicial Center in El Dorado for that hearing, Mr. Yergin, if you make bond. Can you afford to hire your own lawyer here?
No.
Are you working currently?
No.
The court will appoint Chris Pate as your attorney. Sir Gary, recommendation regarding bond here.
Your Honor, in this matter, besides the nature of the charges currently before the court, this is a defendant who the state understands has a history of adjudications, convictions, and failures to appear that the court may consider relevant. At least 3 misdemeanor criminal trespass adjudications for criminal, as well as felony burglary and a felony interference with law enforcement adjudication, as well as at least 1 misdemeanor criminal trespass conviction, misdemeanor theft conviction, at least 7 prior failures to appear, most recently in June of 2025. Therefore, besides a GPS monitoring, a strict no contact order with the victim, the state is recommending at the very least $15,000 cash or surety.
Under the circumstances, Mr. Yergin, court considers that bond recommendation to be on the low side rather than the high side, especially with your record of failure to appear and the fact that this is a presumptive prison offense that you've been charged with. The court will set bond at $15,000, cash or professional surety required. You're to have no contact with the alleged victim, Olga Fowler. No contact or communication whatsoever, Mr. Yergin. And you must appear for your next scheduled court date at the Butler County Judicial Center in El Dorado, Kansas, August 27, 2:30 p.m. before Judge Hart. And again, Chris Pate is appointed as Mr. Yergin's lawyer. All right, Mr. Yergin, anything else you need to address the court about?
That's it.
Okay. Anything else, Mr. Regier?
Nothing to state, Your Honor.
The Yergin matter is in recess. J.D. Comstock?
Yes, Your Honor.
This is State of Kansas versus J.D. Comstock, case number 2025 CR 156. Jared Regier appears for the State of Kansas. J.D. Comstock appears at the jail Zoom location. Mr. Comstock, it appears that despite the thickness of your file, really nothing has transpired in your case yet.
Yes, sir, Your Honor. I've been incarcerated in Arkansas for the last 3 years.
All right. Count 1 of your information alleges theft, a level 9 non-person felony. Count 2, criminal damage to property, a class B misdemeanor. appear to be others. Count 3, theft, a level 7 non-person felony. Count 4, criminal damage to property, a level 9 non-person felony. Count 5, non-residential burglary, a level 7 non-person felony. Count 6, theft, a level 9 non-person felony. Count 7, theft, a class A non-person misdemeanor. Numerous felonies are involved and will not be asked to plead at this time, Mr. Comstock. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is this court. This court's the next docket would be September 8, 2025 at 2:30 p.m. You must fully participate at that time. If you make bond, I will require your appearance at the Butler County Judicial Center in El Dorado and no other location. September 8, 2025, 2:30 p.m. before this court.
Absolutely, Your Honor. I wanted to try to get this taken care of and get it behind me. And like I said, I've been incarcerated for the last 3 years since the accident. And I've been trying to get some medical attention. I need to see a specialist to try to save my right arm. I haven't been able to use it since this incident. And I don't know if I will again. But yes, sir, I want to work with the courts to try to take responsibility for my actions and move forward with my life. And part of that is appearing before you and getting this taken care of, Judge Ricky.
All right. Well, you'll need to talk to your attorney about this. I trust you don't have the resources to hire your own.
No, I got family outside of the state that are willing to help me. But like I said, I've been incarcerated. I was just brought back to Kansas yesterday. I would probably be able to make bond if I could get it lowered a little bit to be able to go out and try to get an attorney. I don't know if you have in Arkansas, they have a monitoring system to where you can put a monitor on me, and my family could pay for that until I get in at the appearance or whatever.
Are all of your other holds resolved by now?
So, sir?
Are you being held on anything except this case?
No, sir, Your Honor.
Okay.
Your Honor, I believe he's got a warrant out of Elk County,
Okay.
and one out of Missouri.
Okay. So apparently you do have other holds.
Okay. I did not know about that.
All right. So James Watts will be appointed to represent this defendant. If you find out you've got the resources and desire to hire a different lawyer, you can at any time, Mr. Comstock. But for now, in this case, James Watts will be your attorney.
Okay.
And we've set your court date for September the 8th at 2:30. You've got an active warrant, which I'm sure already has a bond established, which I think is $50,000 cash or a professional surety required.
Yes, sir.
Well, in light of your other holds, as a practical matter, you're not really going to obtain your release even if you post this bond currently.
Right.
I'm not inclined to alter it at this stage. You can always apply for relief on your bond at some future point in these proceedings, Mr. Comstock. For now, we're going to leave the bond where originally set with Mr. Watts appointed and a court date for September 8 at 2:30. Anything else we need to address, Mr. Regier?
From the state, Your Honor.
Very well. Then,
Thank
Mr.
you.
Comstock, that will resolve your business today.
Thank you.
Amy Dawn Baker.
Yes.
This is State of Kansas versus Amy Dawn Baker. It is case number 25 CR 330. Jared Regier appearing for the state and Amy Baker appearing in the jail Zoom location. We see why you're here, Ms. Baker. Apparently you've got a charge of domestic battery, a Class B misdemeanor. Punishable by up to a $1,000 fine and up to 6 months in jail. How do you plead to this charge?
Not guilty? I'm not sure.
If you're not sure, then the plea is not guilty. I'll accept that plea of not guilty and set your case for future proceedings. I was just looking through the file. You were picked up actually on an active arrest warrant here. We set a bond at $1,500, cash or professional surety. Seems like a reasonable bond.
Yeah.
We'll maintain you under it. Can you afford to hire your own lawyer, Ms. Baker?
Not really. I mean, I can if I didn't have a garnishment coming out of my checks right now for work.
Okay. Darren Patterson will be appointed to represent you.
Okay.
We'll set a court date for you at 8:00 a.m. on October 6th, 2025. A Zoom appearance. You must fully participate.
Okay.
By audio and visual means at that time. You can always come to the Judicial Center here in El Dorado and participate from there.
Yep.
Okay, 8 a.m. It's really early, 8:00 in the morning,
I work at 7, so it's all right.
October the 6th.
Okay.
Judge Webster's Court. You're to have no contact with Danny Sherman.
Yes.
As a condition of your bond, which is, it remains $1,500 cash or professional surety.
Okay.
Mr. Regier, anything else we need to address on Amy Baker?
Your Honor, I'm not sure if the court wishes to make any orders concerning GPS monitor or that the
It does not. It does not.
Very good, Your Honor.
Ms. Baker, show up in court on time and let's get this case taken care of one way or the other, okay?
Yes, sir. All right.
Remember that no contact restriction.
Yeah.
Okay, very well.
All right.
Thank you, members in recess.
Thanks.
Your Honor, I believe that's all the in custodies.
That's consistent with my list. Thank you.
Yep, have a good day.
You too. Brandon Twist. If you'll come on the meeting fully. This is State of Kansas versus Brandon Michael Twist, case number 2025 CR 91. Jared Regier appearing for the state, Brandon Twist appearing on his own Zoom. Mr. Twist, you have a warrant to show cause pending, alleging probation violations, failing to make payments, never reported, no proof of an evaluation being provided. A further hearing will need to be set regarding these allegations before this court. You currently have a conviction in this court, in this case, for possession of drug paraphernalia, a Class B misdemeanor, in which an original sentence of 6 months in the county jail was imposed with a probation order, which apparently, just from the allegations, doesn't appear you've taken seriously, Mr. Twist. But we'll get into that more at the hearing in this case. And we'll establish an appropriate court date for that hearing. Court will assign a court date of August 8, 2025 at 10:00 a.m. So that's 10:00 in the morning on August 8, 2025. Mr. Twist, you must appear at the Butler County Judicial Center in El Dorado, Kansas for that court date, August 8, 10:00 a.m. with you appearing at the Judicial Center in El Dorado. Further, the court will require, as a condition of your bond, Mr. Twist, that you contact Anthony Bauer at the Butler County Court Services Office. Yeah, I think he's the one you're supposed to be reporting to. And you'll need to report to Mr. Bauer as he directs between now and the time of court. All right, Mr. Twist, can you afford to hire a lawyer to represent you on this? Okay, I can't hear you because you muted yourself.
I'm working at the moment. I'd like to say yes. I guess it just depends on how much a retainer fee costs.
You had Chris Pate before. I don't know what the retainer fee would be, so I can't tell you that.
I've got his business card.
Excuse me?
I have his business card. I can give him a call and find out how much that is.
Well, in an abundance of caution, you apparently qualified for court-appointed counsel before. So I'm going to requalify you. You may have to pay his fees back later, but I'm going to reappoint Mr. Pate. And again, the court date for you, Mr. Twist, has been established already as August 8th at 10 o'clock in the morning, with you appearing at the Butler County Judicial Center for that hearing. I see a bond of $7,500 through Butler County bail bonds. The court will approve that bond and maintain you under it pending further proceedings in your case. And make sure that you contact Anthony Bauer at Butler County Court Services as soon as we get off this hearing, Mr. Twist.
Yes, sir.
Okay. Mr. Regier, anything further we need to address on him?
No, Your Honor.
All right. Mr. Twist, I can go ahead and release you from the meeting at this time. Go ahead and make that call to Mr. Bauer.
Thank you, Your Honor.
All right. There's nothing further. That matters in recess. Mr. Regier, that would appear to be the end of the docket that was to be called at this time. Are you aware of anything further that we need to address?
No, Your Honor.
Very well. And that will conclude the Butler County first appearance docket at this time, and this meeting may be ended for all.